Welcome back. I'm Tomas. Like most Californians, I've been conserving energy, like installing these solar-powered lights. But when my electric bill shot up suddenly for no apparent reason, I needed help in dealing with my utility company. As we discussed in the last chapter on informal complaints, I've kept all my bills and receipts and made copies of everything. I also followed the CPUC's guidelines and contacted my electric company about the unexpected high charges. When I didn't receive a satisfactory explanation, I filed an online complaint with the CPUC's Consumer Affairs branch. When I heard back from the Consumer Affairs representative that my bills reflected my usage and seemed correct, I didn't agree, so I appealed the decision. I also spoke with a Consumer Affairs supervisor who agreed with the representative, but I hadn't increased my electric usage. In fact, I had looked for ways to conserve energy, so I decided to file a formal complaint with the CPUC. I took the next step and contacted the Public Advisor's Office. They sent me a formal complaint form and information about the process. To help you and me better understand the expedited complaint process, let's go to our helpful friend, Barbara Rogers. Hi, Barbara.
Hi, Tomas. And welcome to Chapter 3, Filing an Expedited Complaint. To guide us in this process is Kyle Devine, Assistant Public Advisor at the CPUC. Welcome, Kyle.
Hi, Barbara. Hi, Tomas.
Hi, Kyle. I'll be right up.
As Tomas makes his way up to your office, let's begin by discussing what an expedited complaint is and why someone would choose to file one.
Good questions. An expedited complaint is one type of formal complaint. A regular complaint is the other. Both types can be filed by an individual or a business or a government agency if they believe that a utility has violated the California Public Utilities Code, a regulation, or a commission decision. They can be filed against an electric, gas, water, or telephone company that the commission regulates. There are also situations where a consumer is not satisfied with the investigation done by our Consumer Affairs branch, like Tomas. In that case, they can file a complaint, usually expedited complaint.
Well, hi, Kyle.
Hi, Tomas.
Hi, thank you for your time.
Sure, we're here to answer your questions.
Well, I'm interested in the difference between an expedited complaint procedure and a regular complaint. Which one would suit my needs?
An expedited complaint is streamlined or expedited. There's no court reporter transcribing the hearing, no attorneys present, and the hearing is held within 30 days after the utility files its answer to your complaint. A regular complaint does have court reporters present transcribing the hearing. There are attorneys there representing all parties involved. There's no deadline for when the hearing is going to be set, but the entire case has to be resolved within a year. And in an expedited complaint, if there's money in dispute, it cannot exceed $7,500, just like small claims court.
All right, so my electric bill issue definitely falls into the expedited complaint category.
Yes.
So once Tomas makes the necessary copies of his completed expedited form and he mails these and other materials, including a self-addressed stamped envelope to the docket office, what happens next?
His materials will be reviewed. The docket office will already know that his complaint has been investigated by our Consumer Affairs branch, and they'll issue it a new formal complaint case number. And since Tomas included an extra copy of his formal complaint and an address stamped envelope, he will receive an official copy back with the case number marked on it. The docket office will also mail a copy of Tomas's complaint to the utility with instructions for it to answer within 20 days. Tomas also gets a copy of these instructions. Noted on it is the administrative law judge who will be assigned to the case. The ALJ listed will preside over the expedited complaint hearing, and the hearing will be set within 30 days after the utility files its answer to the complaint.
And do I come to this office for the hearing?
Not this office. You'll be notified of the exact time, location, and date. Expedited complaint proceedings are usually held in our San Francisco office or in Los Angeles. But if that's not convenient for you, we'll try to get a location that's in your vicinity. This may push back the hearing a couple of days, but in an expedited complaint, we strive to hold the hearings within 30 days of the utility's filed answer.
Sounds good. Now, if I can only just get over feeling nervous about this upcoming hearing.
Oh, your reaction is normal. The hearing is important. It establishes the record upon which the decision will be based. After you get the response from the utility, you'll have time to look it over and consider your response. And once you've assembled your materials and gathered your evidence, you'll find you're less nervous. And we're here to help you if you have any questions about the hearing. We recommend that you practice your presentation before the hearing. This way, on the day of your hearing, you can focus on conveying your points clearly because the burden of proof rests on your presentation and testimony.
I've installed solar-powered lights outside my house. I've set my heater and my air conditioner to energy-saving levels, as well as my refrigerator and my freezer. I've changed all my indoor lights to CFLs. I turn off my appliances and my computer. I even hang my laundry outside to dry most of the year. I have letters here from my neighbors thanking me for starting up a laundry club on Saturday mornings. We all get together and have coffee outside once we hung out our laundry. In conclusion, I want to contest these two electric bills that say I've used nearly twice as much energy as I've used in previous months. I think they're wrong, and I think my meter needs to be tested.
We're willing to reevaluate his bill, considering the consumer's past usage and the fact that his meter has not been tested.
Okay, well, this concludes both of your testimonies. After reviewing the evidence, I'll issue a decision within a short period of time.
Thank you.
You're welcome.
Seems very straightforward. I can see why it's a little stressful preparing for the hearing since it's up to Tomas to fulfill the burden of proof. But he was well prepared, and the hearing seems like small claims court.
Yes, that's right. We try to keep it like small claims court.
When can Tomas expect a decision?
Usually 3 months after the hearing is held, the administrative law judge will issue a proposed decision, and both Tomas and the utility will have a chance to comment on it before the commissioners vote on the decision.
And assuming that Tomas's case is decided in his favor and his electric bills are readjusted, all's well. But what happens if the decision supports the electric utilities side? Is there any recourse for Tomas?
Yes. Once the commission votes on the decision, Tomas has 30 days to file an appeal. We call that an application for rehearing. But he can only file it if he believes that the decision is unlawful or if it's based on wrong information.
You mean Tomas can't file for rehearing if he doesn't agree with the decision, but he can file if he feels the decision is based on a legal error?
Yes, that's correct.
Well, who can help advise me if there was a legal error or not? Do I go to the public advisor's office?
No. Since it's a commission decision and you're saying that it's illegal or based on wrong information, we cannot advise you. That would be a conflict of interest. But the public advisor's office is here to help you if you have any questions about the appeal process.
So what happens if I do appeal? Do I have to go through the hearing process all over again?
No. The commission will discuss the appeal and will issue a decision explaining the changes, if any, it makes to the original decision.
All right, Kyle, thank you.
But to put the expedited complaint process in perspective, most folks come to the CPUC with questions and complaints that are resolved quickly and amenably.
Yes, that's right. Many complaints can be resolved through mediation or some other form of alternative dispute resolution and bypass the need for hearings altogether.
I like that. And this is the subject of our next chapter, Alternative Dispute Resolution. Thank you, Kyle, for your thorough explanation of expedited complaint procedure. And thanks to all of you residents and small business owners for your interest. To continue getting assistance with your questions, go to the main menu and access specific chapters. I'm Barbara Rogers, looking forward to seeing you soon.
And I'm Tomas Roman with materials about filing expedited complaints. Join me in the next chapters as we continue to get your questions and complaints addressed.